Hey everyone, and welcome to BarTalk, the official podcast of the North Carolina State Bar. I'm Peter Bolak, and I'm here with
Brian Oaten, and I feel like it's important to mention our sponsor for today's podcast, Taylor Swift's new album, Midnights. Meet Me at Midnight.
We've really appreciated our relationship with Taylor over the years and her support of this podcast. But today we want to talk about the annual meeting of the North Carolina State Bar that happened a couple of weeks ago in October, and give you an update on all the things that happened and all the committee work, ethics opinions, grievance numbers, and all the news from here in Raleigh at the North Carolina State Bar.
Okay, but before we go further, I do feel like we need to, since we're an ethics agency, clarify that no, Taylor Swift is not affiliated with this podcast in any way, but we certainly would hope that she would be. So Taylor, if you're listening, by all means, give us a call. Our
listening numbers are close to Taylor's in a lot of ways. So at the meeting a couple of weeks ago, Brian, we had a great inaugural dinner for our new president, Marcy Armstrong. Yes. She takes over the reins from Darren Jordan, who had a great year as president. Marcy is a family lawyer from Smithfield, and she's been an officer with the State Bar now for a few years and was a counselor before that, and we're just thrilled to death to have Marcy as our president. Taking the spot of president-elect is Todd Brown, a lawyer from Charlotte, and our new vice president, who was elected at the meeting, is Matt Smith, a lawyer from Eden, North Carolina. Eden is a place in North Carolina, guys. You should check it on a map. It does exist.
We've confirmed this. We had to look into it, but it does exist.
Yeah, but Matt is going to be a great officer, and we're excited to have him. So that happened on Thursday night, and then Friday morning at the State Bar Council meeting, we were honored to have Chief Justice Newby address us on the state of the judiciary and give us an update on what's going on with the administrative office of the courts, talking about e-courts and opening up the courthouses and access and his trips across the state. And it's always an honor to have the chief speak to us in person. But now to the meat of the meeting. Let's talk about what's going on with some of these important committees. Brian, the ethics committee was out in full force again.
Yes.
This past quarter. I know that there were some new inquiries and an adopted ethics opinion. Why don't you tell me about those?
Sure. So the new inquiries, we've got a couple of new inquiries this quarter, two in particular. One dealing with a lawyer who's serving as a mediator and wants to draft an agreement between pro se parties. This was an issue that was brought to us by the Dispute Resolution Commission. So we're looking into that and certainly are looking for a lot of feedback from other mediators that are out there on the topic. We also have another inquiry addressing the confidentiality that can be imposed in a settlement agreement. Certainly there's a lot of different confidentiality provisions that get imposed upon the parties and even to some extent the lawyers, but exactly what extent can confidentiality be imposed upon a lawyer in talking about a case after the representation is concluded? That's a question that's been posed to us, and the Ethics Committee appointed a subcommittee to study that very issue. We also had one new opinion adopted after publication the prior quarter. It deals with a very nuanced issue of a lawyer that's calling a public adjuster who's also serving as a witness in a particular case when that public adjuster is being paid a contingency fee. That's a statutorily authorized contingency fee. So the opinion says that a lawyer can do just that, even though there's a general prohibition on paying a witness for their appearance at court. But it would encourage folks, if you deal with that area of law, take a look at that ethics opinion. It's 2022 FEO 5.
That is one of those ones that keeps us all up at night, Brian. I'm glad you guys got that resolved.
We're here to serve.
That's right. And the Ethics Committee is hard at work on a number of other issues. Brian, I know there's some active subcommittees. Why don't you just title those for me?
Yeah, that's right. So we had, I guess, another quarter of meetings. We actually had two meetings of a subcommittee studying an inquiry concerning the sale of a law practice and really how you deal with old client files, because there's a lot of practices out there that are looking to be sold, looking to be transferred to a new attorney. But what you do with those client files can be a very tricky thing depending upon the practice area that you're in. So that committee met twice this past quarter, and they're going to continue to meet as they try to hammer out an opinion that offers sufficient guidance to all lawyers. But we have another inquiry that remains in subcommittee, and this is the one dealing with billing for overlapping services. Yeah,
we talked about this the last couple podcasts, or at least the last one, and and it's, it felt like we were headed towards a relatively easy resolution on
Right.
the idea that a lawyer who is billing one client for their time in a certain matter for whatever they're doing has a duty not to bill another client their regular rate, and needs to kind of offset those charges or not bill the second client, or the idea of not billing more hours than there are in a day or that you're using.
Right.
And I thought it seemed like we were on a pretty good path, but as in a lot of these things with ethics, it's become a little bit trickier and more nuanced than we originally thought.
Yeah, that's right. Sometimes things just seem simple and straightforward, but when you get into the weeds, you really find out how nuanced the issue is, and really the ethics committee strives to publish ethics opinions that offer guidance, that don't necessarily hinder a lawyer's ability to practice, but ultimately protect the public. And I think that's one of the issues here of just what does the public expect, what sort of harm are we dealing with, and what's the most practical thing to impose here. So this inquiry was published previously. We got a fair amount of comments on it, and it is being studied by a subcommittee. It's going to remain in subcommittee for at least one more quarter as we try to figure out the answer. But we're certainly hearing more voices, and if anybody out there is listening and has an opinion on this particular topic, feel free to submit your opinions to ethicscomments@ncbar.gov, or tune in to the subcommittee meeting, which will be streamed on the State Bar's YouTube channel.
And a lot like the previous subcommittee you mentioned, a sale of a law practice, a lot of this stems with the difficulty of trying to craft opinions and rules that apply to all different types of practice.
That's right.
And so, that's the difficulty. You want to have a rule that's clear enough that gives guidance to all the different kinds of lawyers out there, and we'll get there. It will just take a little extra time.
Right.
The last subcommittee, Brian, is an interesting study on an amendment to Rule 1.8E about gifts or monetary loans, money to clients, right?
Yeah. So
not loans, but gifts,
loans, more so financial assistance.
That's
1.8E, for all you ethics nerds out there, 1.8E deals with or provides a prohibition for providing financial assistance to litigation clients, and it's something that there's some. We won't get into the details of the purpose of this. This
you never
rule.
really wanted people to use that as a way to attract clients or to offer things as an incentive to using them as a lawyer.
I wasn't going to say it, but now you're going to make me refer to champerty and maintenance. That was the purpose of the prohibition.
I'm out of here.
So but really the thing that brought this to the ethics committee's attention was in 2020 the model rules, which reflected our North Carolina rule. The model rules were amended to insert a humanitarian exception. And this exception essentially creates a very limited circumstance where a lawyer could provide financial assistance for basic living expenses to a client. Those limited circumstances, though, the lawyer has to be representing an indigent client pro bono. And if they are in that particular situation, whether they are an individual lawyer representing an indigent client pro bono, or they're working through legal aid or a law school clinic, you can provide modest gifts for basic living expenses. But there are some parameters there that essentially the lawyer can't advertise the ability to provide these gifts. They can't make any promises to induce the client to retain their services, and they can't request repayment of these gifts. So that's the amendment that's in the model rules. It was passed in 2020, and it's something that the Ethics Committee wants to take on now to study whether it should be included in North Carolina as well.
I think that's really an interesting one, and hopefully can come to a good resolution that's helpful to everyone.
Right.
So that's the work of the Ethics Committee this quarter. Again, as Brian mentioned, if you have ideas or thoughts or comments on any of these issues, please send them in to ethicscomments@ncbar.gov. You can send them to us directly, and we really want to consider those, and the committee always considers any comments that we receive.
Absolutely.
A big announcement from your Brian and Peter friends here at the podcast. The October meeting is the meeting in which the council sets the dues and recommends the amount for the client security fund assessment each year. And once again, the dues are going to be set at $300. That is continues the streak of the longest period of time without a dues increase in State Bar history. That will be $300. And even better news is that the client security fund's operating budgets are sufficient at the moment, to which the State Bar Council and the Client Security Fund Board have recommended to the Supreme Court that the assessment for the Client Security Fund in 2023 be
$0.
$0. So when you're going in to pay your dues later this year or the beginning of next year for 2023, your bill is going to be $300. So you're actually going to see a reduction. And so like in Moana, you're welcome.
now I'm out of here.
All right. So,
let's talk about some rule amendments.
Yes, we've got some breaking news, Brian. You want to share with us?
Sure. So we had some pending rule amendments from the past couple of months, particularly dealing with the rules of professional conduct. There was an amendment to Rule 1.19 that prohibits sexual communications between a lawyer and a client. There were some amendments to the confidentiality rules, 1.6, and as well as a provision in 1.9 that deals with former clients, that essentially says that a lawyer could talk about information that concerns a former client if that information is in the public record or was disclosed at a public hearing or is otherwise publicly disseminated, as long as disclosure is not detrimental to the client. And so those amendments were sent to the Supreme Court after being vetted by the council and approved by the council. And as of Wednesday, November 2nd, the Supreme Court approved both of those rule amendments. So, and particularly with regards to the first rule amendment I mentioned, North Carolina is the first United States jurisdiction that specifically prohibits sexual communications between lawyers and clients. And of course, that amendment came from not just some board staff members at the State Bar, but from the unfortunate reports that the State Bar has received over the past couple of years of lawyers acting inappropriately and sending inappropriate messages to their clients. So that is now in the rules of professional conduct, and certainly would encourage everybody to visit the State Bar's website to review those rules to make sure they are up to date.
And to revise your conduct accordingly.
Absolutely. But there were also some administrative rules that were approved. Peter, do you want to talk about some of those?
Yeah, some various administrative rules. Honestly, nothing huge to report there. Little changes as it relates to seeking inactive status. Now that can happen in between quarters for lawyers who want to seek inactive status, and other small changes as it relates to how the State Bar reports its proposed rule changes to the Supreme Court. But I think that the biggest change, the biggest additional rule amendment topic is this proposed CLE rules.
Yeah, those CLE rules have been pending for a while. Those of you that are listening, you've probably seen some rounds of publication. I know there's been a lot of talk about them. So, Peter, you want to give us a status update?
We're going into round 3 of publication here. And we've, as you've probably seen in the journal and online and with our messaging, we've been looking at these CLE rules for a really kind of a universal approach to changing them, taking a look at how we do the financial side of it, how we do the annual reports, lawyers' credit requirements, the reporting period. And so, those changes continue. The CLE board continues to look at these rules. They have not been officially put up to the council for actual approval yet. This quarter, after a lot of comments and a lot of study by the board, the board is proposing an amendment to its proposed rules, which is, we're amending our proposed amendment to the rules to bring carryover credit back to 12 hours per reporting period. So initially we had proposed eliminating carryover credit. That didn't go over well with all of you. Then we moved it to 6 hours, and now we've brought back a full 12 hours of carryover credit per reporting period. The CLE board is going to continue to look at the rules this quarter, including the proposed fee schedule, and take a look at the reporting period that we've proposed, the 3-year period, and see if we still think that's the right path for us to take. And with the hope that there'll be a full set of rules to present to the council in January. I think there'll be a final full publication of what the proposed rules are going to be. depending on the comments of that and what we've learned, potentially in April, the council could see these rules put to them for potential approval and then to the court. And the earliest that any of these rules would become effective would be March of 2024.
That's right.
So we'll continue to communicate those potential rule changes, and anything big out there will get published in the journal as well.
Yeah, so everybody keep an eye on the journal, keep an eye on the State Bar's website. Again, your comments did impact these proposals, and so feel free to continue to offer feedback because truly the feedback makes the end product that much better. So.
Brian, we have a new committee at the
Right.
State Bar that had its first meeting this past quarter. That's the Access to Justice Committee. And we can talk about that, and then also as part of that, the study inside that committee of the Legal Deserts Subcommittee.
That's right. We have, and this really stems from a variety of efforts. You know, we had a subcommittee studying regulatory change over the past couple of years, but we also have had a number of committees and really subcommittees of the Issues Committee that have studied a variety of issues, like the pay of court-appointed counsel and why folks aren't signing up for the court-appointed list anymore. There's just been a number of issues that the State Bar has looked at that really do have an impact on access to justice and the public's access to the court system as well as access to legal services. So in July of this year, the State Bar Council appointed or created a new Access to Justice Committee. And this committee is really tasked with carrying out one of the provisions in the preamble to the Rules of Professional Conduct, which says that lawyers have a responsibility to make corrections in the system, to make efforts to ensure that everyone has access to our justice system. And so with the Access to Justice Committee starting up here, we're looking at a variety of issues. One of the first meeting, really, we talked about the different things that are happening in our own counties that perhaps we didn't realize were access to justice solutions, because each county is different and each county faces its own problems. But one of the issues that they are looking at is our legal deserts. And I know we've talked about this before, that legal deserts is a new subcommittee studying this issue of kind of a growing number of geographic regions in this state and really across the country where there is a lack of lawyers. The definition of a legal desert is that there's one lawyer or less than one lawyer for every 1,000 residents. And you can imagine how that impacts not just somebody's access to legal services, but also, say, if you don't have many lawyers in that district, like we have in a number of our counties, you may only have one or two people that are on the court-appointed list. And for somebody who is in need of appointed counsel, they don't really have anyone that can take on their case and take that on with the prompt need for handling it as soon as possible. So ultimately, the Access to Justice Committee is going to be around for a long time, and we're going to be looking at legal deserts as well as a number of other issues really for the long haul.
And so again, and this is like a broken record, but we're always interested in your ideas and thoughts and comments on this. You know, we are the State Bar. Lawyers all together are the State Bar, and we have to come up with these solutions. It's not just us here in the building or just the counselors. I mean, this is an effort that we all have to engage in as our duty under the rules and under the preamble. That let's see what's working out there across the country and here in the state, and let's make things better. So I know everyone was waiting the last 15 minutes for the big news, and that starts with the results from the Grievance Committee's meeting on October 21st. There were 292 items considered this past quarter. Of those 292 items, 257 of those files were dismissed. For you lawyers out there, just take that note, that there isn't a concerted effort to go out after all of these lawyers. We're trying to focus our efforts on the lawyers that are committing these rule violations that really raise an issue as it relates to public protection. 4 lawyers were referred to the Trust Account Compliance Program. 5 lawyers received letters of warning. 7 lawyers received admonitions. 5 lawyers received reprimands. 1 lawyer received a censure. And 8 lawyers were referred to the Disciplinary Hearing Commission for potential trial as it relates to potential suspension or disbarment. So that's the grievance committee numbers, and I know the other big news that you all want to hear are the random audit counties, Brian.
That's right. The random audit does continue despite this, despite us entering the holiday season. So judicial districts.
What a Christmas present,
right?
And
that's just what the state bar does. So judicial districts for the fourth quarter selected for the random audit: District 12, composed of Harnett and Lee counties, and District 22, composed of Caswell and Rockingham counties. You will be up for random audits, so perhaps our random auditor, Ann Parkin, may be getting in touch with you.
Well, that does it for another episode of BarTalk. I really enjoyed spending the time with you here, Brian, and getting to know about the ethics process, including all that public adjuster stuff. If there's anything that you, our listeners, would like to hear about the state bar from us on a future podcast, please let us know. Again, send us your comments and thoughts on any of our proposed rules or proposed opinions. And other than that, we'll see you next time, and have a happy holiday if you don't hear from us before January.
Meet me at midnight.